Regulating Indian Cyberspace. Introduction to Internet Law and Policy. In our brief discussion, we look at the development of Internet law. And as we look at Internet law and understand the rules and regulations and the governance of cyberspace, we cannot ignore the role and importance of architecture. It is this decentralized routing system, this dumb network, that gave and gives rise to some of the most easy communication exchanges and yet some of the most complicated legal challenges. In terms of internet architecture, we must remember what has come to be known as Gilmore's Law. The net interprets censorship as damage and roots around it, meaning that the medium or the architecture of the internet is designed to connect. In the early days of the internet, you had many arguments for an independent cyber law or an independent law relating to cyberspace. Later, we have come to understand that the internet is a medium which can be regulated by the regulation of its layers. Winkler proposed that in communications, the three layers to look out for are the physical, the digital or the code, and content. Further, Lessig said that for the internet, the code is the most important in terms of regulation. And it is this mix of architecture plus law that gives rise to uh, what could be termed as perfect regulation. Our own Indian Information Technology Act aims at regulating the internet. And there's a chapter in one of my books titled Regulating Indian Cyberspace, which looks at the impact of the IT Act on jurisdictional issues. A few years ago, John Goldsmith and Timothy Wu, in a way, ended the internet jurisdiction and cyber law argument in their book, Who Controls the Internet, where they put forward enough evidence to show that on the internet, law enforcement or a national government could control every minute detail if they wished. The impact of the IT Act in a phrase, functional equivalence. That means from the year 2000, from the 17th of October, when the IT Act was enacted, everything that every act that was online or electronic would be treated at par or equivalent to acts occurring in the traditional medium. Electronic commerce was a powerful objective of the new IT Act, and it is important for lawyers and managers to understand the role of the medium in uh, the act or the crime, whether the role of the medium is incidental, whether it is content related, or whether it is integral to the act. In terms of enforcement, there are lessons perhaps to be learned from various experiences around the globe, including perhaps the American experience of uh, their law enforcement bringing to book uh, hackers, intellectual property violators, and their simple theory that if American law can't be exported, the criminal can be brought to the United States using any mechanism, maybe even an invitation, as in the case of Adobe Systems versus Dmitry Skylorov. When we are looking at managing information systems, both from a legal and from a functional managerial point of view, it's important to understand the distinction between the machine and the medium. If we are going to understand what is a cybercrime, because remember, a cybercrime relates to the medium, and uh, we are looking at what transpires over the medium, where the machine is but a crucial link. It's very important to focus on relevant issues, focus on the appropriate classification of offenses. In terms of uh, cyber forensic, uh, it's important to look at the discovery of the criminal act, the detection, analysis, collection of evidence, what we call the evidence trail, and looking at uh, collection of evidence during and after a crisis. So, part of crisis management is not only to preserve the working of the machine and preserve evidence, but to see that the evidence collected is presentable in a court of law. In terms of jurisdiction and the determination of contact with a jurisdiction, we have a few theories. One, of course, is the permanent establishment doctrine. As we know, the OECD defines a permanent establishment as the existence of a fixed place of business and prescribes that a business be established at a distinct place. Permanent establishment could be based on the physical location of the server, the location of the files, the permanence or the relative permanence of the internet site, exemption of applicability under a treaty, the use of site display, sales, ordering, instruments of delivery, distribution points. Presence could further mean incorporation in a state or territory, licensing or contracting arrangements in the territory, maintenance of an office, whether rented, leased, or owned, presence of representatives, so on and so forth. The Information Technology Act can be summed up perhaps as a two-in-one legislation, with the first half from chapters 1 to chapter 7 uh, dealing with electronic evidence and electronic governance issues, including the security of electronic records, electronic signatures, so on and so forth. And chapters 9 onwards dealing with cyber crimes, offenses, penalties, including duty and liability of intermediaries, so on and so forth. In terms of electronic evidence, following our functional equivalence doctrine, the Information Technology Act has brought about changes to the Indian Evidence Act as well. So there are changes to the Evidence Act, including Section 65B, presumption as to the admissibility of an electronic record. We have leading cases such as Dharambir versus CBI, which looked at the totality and the inclusiveness of electronic evidence and stated that the entire digital device should and must be available for examination. The judgment importantly said that once a blank hard disk is written upon, the entire disk becomes an electronic record. So, in terms of definitions, we need to know digital evidence, original digital evidence, duplicate digital evidence, copies, and all of them have specific meanings under the law. Offences categorized in Section 65 and Section 66: tampering with computer source, code, and documents, transmission of offensive messages, dishonest receipt of stolen computer resources, punishment for identity theft, cheating by personation, violation of privacy, cyber terrorism, and the publication of obscene material and the transmission of obscene material. Very important for corporations and their managers and directors. The amendments to the Indian Information Technology Act introduced the duty of an organization to maintain reasonable security practices and procedures under Section 43A. What is a reasonable corporate security system? Perhaps at present we can look to examples such as ISO 27001. And if an organization does not maintain reasonable security practices, not only is the organization liable, but Section 85 and the way it reads, it says that every person who at the time the contravention was committed was in charge of and was responsible to the company for the conduct of business of the company shall be responsible and liable for the act that is committed. So it's very important as a compliance step for the organization's IT resources to be governed by strong, robust, and practical IT use and security policies. Some of the policies that need to be in order, drafted, or as I say, redrafted, include a privacy policy, mandatory under the IT Act, a cyber law policy, an e-security policy, a software usage policy, internet usage policy, email policy, cyber insurance policy, e-writing policy, training policy, and e-crisis communications policy. Further to this, an organization which runs a website also needs to reformulate its website's usage policies, terms and conditions for use, and the user agreement. And with this, we come to an end of this brief introduction. If there are any queries and questions, please do feel free to reach out to us.